Hey everyone, welcome back to the channel. Today we've got a couple of sovereign citizens bringing some truly bizarre arguments into court. We're kicking things off in Judge Simpson's courtroom, where this defendant seems to have fully committed to the sovereign citizen rabbit hole. The legal theories are about to get wild, so let's jump right into it.
Power.
Government vote for the people.
Mr. LeBeau's case. Laura.
Joshua. Thank you, Your Honor. Mr. Warren, can you state your name, sir?
My name is Joshua William Wara. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No,
Okay. All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
no. I know
You
the
don't
mission.
understand? You,
I'm a jailhouse lawyer.
Pardon?
I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolf Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati?
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited to
Thank
do
you,
so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolf Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay,
They're
but
the
I've got to
Ku
do
Klux
something. I've got to
Klans.
do something. I've got to
With
do
the
something with your
NDOC.
case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10
you-
times
if
the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into $5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $500.
I'm certainly not a mathematician, and I'm definitely not claiming to be a lawyer. But you don't need either qualification to recognize that 5.6 trillion multiplied by 10 doesn't magically become $560 trillion. Yet somehow, that's exactly the kind of math we're dealing with here. And apparently, we're expected to take this argument seriously.
Which is
I'm
my
with you. I
right.
did that. I did the math too. Listen, here's the thing.
Mhm.
I have to advise you because if you are going to represent yourself, what you're here on,
I'm doing
okay?
it over Zoom because they're
So
trying
you're
to kill
here
me.
on a complaint that alleges that on October 15, 2025 on South Main Street
The Pentagon's
in the
using
city of
prisms
Ann
to make
Arbor,
the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount because I can sue because it's conspiracy to murder. And sovereign law would make it 100 times the amount, but since it is conspiracy
Okay.
to murder, sovereign law
I'm with
does
you.
not
I
exist.
got you. I just have to let you know what you're
Which
charged
means
with.
I can sue for
There's
1,000
also a
times the
count 2
amount.
on the complaint that alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay. So there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Cedric Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel,
No, I do
Then all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen-
trial,
listen
not a
to what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
backed
any point you do,
on objective evidence.
if
A
at
bench
any
trial
point
is
you
objective
do
evidence.
want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I would
Now
like
that
to
I've
do a
gotten
bench
through that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial can
that's not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law and it's conspiracy to murder and Donald Trump and Elon Musk are involved and I can sue for 1,000 times the amount and sovereignty
Your Honor,
does
if I
not
can
exist
if I
because the
can-
amount of money that
I
they
don't know,
put
I've
that
not been
Elon
very good at it,
and
but
Donald Trump and Elon
Oh,
Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peak and Ellen Wara all have estates that and residencies in states that do apply the
At first glance, you might assume this guy has completely lost touch with reality. But unfortunately, extreme threats and bizarre courtroom behavior aren't exactly unusual in sovereign citizen circles. We've seen similar situations before, including people making outrageous threats against judges, attorneys, and anyone else who challenges their beliefs. When someone turns a legal dispute into personal revenge, things can get seriously disturbing.
I gotcha. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like to
one.
give
So we would
Dr.
need more time. The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him to first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do. Sir,
Frederick Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't, yeah.
Okay, but you
There's
haven't
too
seen
many
the
people involved.
You
You have a
haven't
Neuralink
seen.
in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
It's based on
listen.
factual evidence. The jury
No,
trial can be bribed.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please, with all evidence. I would like to.
You want to represent
on record and
yourself?
all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Warren.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolf Mack, Donald
We're not
Trump,
bringing out those people
Elon
down.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm going to indicate he doesn't want us to.
If you were actually present when the alleged crime happened, you already know what you personally witnessed. You don't suddenly need a mountain of discovery just to remember what happened right in front of you. Sometimes the simplest explanation is the obvious one.
Or defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm going to
Yes.
give you your preliminary examination. So your preliminary examination will be set in person on
Your Your Honor, I'm so used to just
And,
saying, yes, sir.
Adolf
No, I
Hitler
know,
is in
but
the
I
judicial
realize it's
court
close, but,
with, Carol
it-
Conkey and East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She was at 22nd Judicial Circuit Court with Feiger and Ellen Warren and Jeffrey Peake. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial now.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's
That's a
today?
yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolf Mack. I'm giving him the electric chair. And I'm
Alright.
suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolf Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm gonna
And
do.
Donald Trump.
I don't know that we'll be able to go, given how you're
Yes,
acting.
we will.
but
I want
I'm
a
gonna
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolf Mack, JP Morgan.
I'm gonna set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. I'm not, if I let the PD off, because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr. LeBeau, you are still on the case. Because I think the more the merrier.
Thank you, Your Honor.
You're welcome. No, you're not really thanking me, but I get it. All right, thank you. Thank you, sir.
Apparently, we're taking another trip down the sovereign citizen rabbit hole, and this time we're heading to Colorado. Here we have a defendant confidently presenting arguments that don't seem to hold up under even basic legal scrutiny. Thankfully, the judge isn't interested in playing along and has no problem addressing these claims head-on.
Good morning, or rather good afternoon now for the defense. State your first and last name for the record.
Robert Richards.
And with that, go ahead and have a seat. We're going to go ahead and do housekeeping. So we're here for motions, and there's no resolution in this case?
No, Your Honor.
All right. And so with that, did you receive Mr. Richards' motion to dismiss the charges in this matter?
Yes, Your Honor.
And Mr. Richards, would you like to supplement the record by any oral arguments?
No, ma'am.
All right. And so for the people?
Your Honor, we would respectfully ask the court to deny this motion to dismiss. There is a factual basis for the charges as well as an unwillingness by Mr. Richards to come to a resolution in this case. So I believe that going to trial is appropriate resolution.
And so I just want to make sure I clearly heard you. You asked me to deny the motion because he's unwilling to resolve the matter?
We have not come to a resolution in this case.
Do you think that's a legal basis in which the court could do that?
And additionally, I believe there are enough facts to support the charges, Your Honor. And I believe that the people can prove this case with a reasonable certainty at trial.
And so as to Mr. Richards' motion, did you actually pull the cases he has cited?
I apologize, Your Honor.
As to Mr. Richards' motion, did you ever pull the cases that he has cited?
Yes, Your Honor. But the people would argue that these cases are not pertinent to these charges.
Can you tell me why?
Under Flournoy v. First National Bank, Mr. Richards quoted, "If the state converts a right into a privilege, the citizen can ignore the license and..."
And this would be under which case?
He quotes Flournoy v. First National Bank of Shreveport. It's 197, California.
And before you go any further, because I did pull these cases, and one of them, the site's incorrect. All right, and you may continue as to Flournoy versus First National Bank of Shreveport.
he quotes that case saying, if the state converts a right into a privilege, the citizen can ignore the license and fee and engage in the right with immunity. I apologize, Your Honor. I believe that's Shuttlesworth v. City of Birmingham, 373 U.S. at 268.
Okay, because that's the case that I could not find,
I also could not find that case, Your Honor.
but you were able to locate it?
I was not able to locate that case, Your Honor.
I'm sorry?
I was not able to locate that case, Your
Representing yourself does give you some room to make mistakes, but there's still one very important rule. If you're going to rely on legal precedent, make sure the precedent actually supports your argument. Shuttlesworth v. Birmingham is absolutely a real and historically important case involving civil rights. The problem is that it has nothing to do with claiming you can drive a vehicle without obtaining a valid driver's license.
convert a liberty into a license. So I believe that case was decided in 1943 about wares and merchandise. I don't believe that pertains to a driver's license, and as the facts in this case do, Your Honor.
So with that, Mr. Richards, would you like to respond to her arguments to the court as to why I should not grant your motion to dismiss based on the cases you have cited?
Well, we can start with Article 6, Clause 2.
Of which constitution?
The United States Constitution.
Let me go ahead.
All persons born and naturalized in the United States are subject to jurisdiction are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of liberty or property without due process of law, nor deny any person within its jurisdiction equal protections under the law. Now I'd like to cite the definition of liberty: the freedom and exemption from extraneous control, the power of the will and its moral freedom to follow the dictates of its unrestricted choice and to direct the external acts of the individual without restraint, coercion, or control from others. I apologize. The first amendment I read was Amendment 14, Section 1. Article 6, Clause 2, all debts, contracts, and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. The Constitution, the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state contrary to the contrary withstanding. The senators and representatives before mentioned and the members of the several states legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. The United States Code is the supreme law of the land. All states are required and bound by it. And the USC recognizes no law for a driver's license, for inspection, for insurance, or for registration. And the only law that they do have on the books is regarding registration for commercial vehicles. The word driver is a commercial term, which means that you're using the road for a commercial purpose or for a hire purpose. I have stated since I met with the officer who initially pulled me over that I am a private traveler.
All right. Any additional arguments you'd like to make to the court?
I mean, I can cite the right to travel, which is Second American Jurisprudence, Constitutional Law, Section 329, page 1135, which states personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not merely a privilege which may be permitted or prohibited at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in person but in safe conduct. And personal liberty consists of the power of local motion to change situations or removing one's person to whatever place one's inclination may direct without imprisonment or restraint.
I've been noticing this particular citation appear more and more in sovereign citizen arguments lately. It supposedly comes from a 2021 case involving a South Carolina defendant who tried to take his argument all the way to the Supreme Court. But here's the problem. The section being cited isn't some groundbreaking Supreme Court precedent. It's essentially a reference to a filing concerning permission to proceed in forma pauperis, meaning without paying certain court fees. That request was denied, and the case was dismissed. So calling this some revolutionary Supreme Court ruling completely misses what actually happened. Now it's time for the judge to make her decision.
I can read the USC that regards the requirement for registration since we have a registration here, but I don't feel like that's really necessary at this point, do you?
Well, that'll be up to you. I'm giving you your time before the court.
49 USC 31704 vehicle registration. After September 30th, 1996, a state that is not participating in the International Registration Plan may not establish, maintain, or enforce a commercial motor vehicle registration law, regulation, or agreement that limits the operation in the United States of commercial motor vehicle. This is not registered under the state law if the vehicle is registered under state law participating in the plan. And that's USC 4931, subsection 31704.
All right. And thank you for that. And with that, the court will now rule as follows in this case. As to Mr. Richards' motion to dismiss, he has cited as his legal authority Murdoch versus Pennsylvania, which can be found at 319 U.S. 105. That's a United States Supreme Court case from 1943. And then we have Flournoy versus National Bank of Shreveport, which can be found at 3 Southern 2nd, 244. That is a Supreme Court of Louisiana case from 1941. Both are still good case law. The court did try to find this Shuttlesworth versus City of Birmingham. The site is 373. I also looked at 375 US 260. That case does not exist under that site.
Okay.
And as to each of these cases, we are here on this driving under restraint and an expired license plate charges. The first is a Class A traffic infraction. The second is a Class B traffic infraction, ineligible for a jury trial, but a court trial. And as to Flournoy versus the First National Bank of Shreveport, the actual issue in that case is that they did challenge, and that would be Flournoy challenged a statute that was limiting in value bank shares for taxation. The court found that that was unconstitutional. It has no bearing on a driving under restraint or a license plate being expired. And then in Murdoch versus Commonwealth of Pennsylvania, what was happening there is that the city of Jeannette, and it was an ordinance by the city of Jeannette in Pennsylvania, was prohibiting the sale of goods, wares, and merchandise of any kind within the city by canvassing for or soliciting without a license. And the United States Supreme Court found that that was in violation of the Constitution, the United States Constitution, freedom of speech that is guaranteed by that First Amendment, because it was preventing people that had religious beliefs or were on the streets just preaching the gospel from distributing religious literature and then having personal visitations with individuals as they walk by. And they found that that requirement prohibiting any sale of goods, ware, or merchandise of any kind without a license was in violation of the First Amendment. And so as to all that has been cited by Mr. Richards, I appreciate it, but we do have laws here in the state of Colorado that do require you to have a driver's license and that privilege, and also have your vehicle license.
I'm still waiting for the day a sovereign citizen actually proves these theories in court and wins based on the merits of their argument. Until that happens, we're left watching the same claims get presented over and over again, followed by the inevitable realization that reality doesn't work the way they think it does.
Housekeeping. So have you gotten down to the district attorney's office and received your discovery in this case?
No.
All right, you will need to have your discovery because the people are indicated they have 2 audio files and 3 video files for a total of 5 media files that they may be using in a trial. You will need to be able to review those because I'm going to set some deadlines because I need the parties to confer about what will be coming in and what will not be coming in. And it'll be extremely beneficial if you know exactly what that is. And so during housekeeping, what I do is I go back to the date and time that a case was filed with the court. And I review all motions or notices that could potentially affect trial in this matter. And since the not guilty plea was entered and the JASP order went into effect, the people filed 1 notice of endorsement of witnesses on just September 12th of this year. Did you receive a copy of that? And could you approach? Here's all I'm going to give you a hand delivered to your copy. These are all the people that they possibly or potentially could call, and that's for you. You can keep that. That's yours.
Wow.
Oh, that's who they're going to call or potentially call. That's their potential witness list.
So the officers that were there on scene?
Yes,
There were
whoever.
3 officers, not 4.
And they're saying there's 4. So,
I saw 3.
and so that's who they're intending. They could potentially, they could tell you that they will actually call those 4 officers or whoever the 4 witnesses are listed because I didn't look at it that closely. But that's who they're intending or potentially could use as witnesses in this case. If you want to know how those individuals are related to this case, that's where the discovery comes in because there should be reports from those individuals or some type of statements or some type of mention of those individuals in somebody else's reports. That discovery will tell you exactly who those people are, hopefully, and also we have all these audio and video files. So with that, would you like to go down and get your discovery? In this case, it's free.
Yeah.
All right. So could you give them your address to your office? And you need to just go to, I think the fastest way is to go down there. Is it the fastest way to go down there and get it? Or does he do it online or?
To request it online first, and we have to process it for him to be able.
So what happens if he goes down to your office? Can you request it as he's standing in your lobby?
So I believe Central Services needs some, I believe they said it's 7 business days at least to process discovery.
I know, but that's for the processing time, but the actual request. Can a person go to your office and request a discovery in person?
I'm not sure with that method. I think it's usually online, but online should be fairly easy too.
And I'm going to assume there may be a mechanism because not everybody has access to a computer.
Yes, Your Honor.
So would you, if you'd like to, go down to the office and see what they have to say about how you can request that. Give them your address. You'll have to go directly to their district attorney's office.
Going to ignore
And nobody is taking away some constitutional right to locomotion, because the Constitution doesn't give you an unlimited right to drive a motor vehicle whenever you want. What's being challenged here is the completely different claim that someone can operate a car on public roads without a valid driver's license. That's not a constitutional right. That's a licensing requirement.
Authority to actually enact these types of statutes.
Okay.
Okay. And so with that, for the people, did you file any additional motions or notices that the court is not aware of?
No, Your Honor.
And there were none other than the motion to dismiss filed by you, Mr. Richards. Is that correct?
Yep.
Okay. So again, people have 2 audio files and 3 video files for a total of 5 media files. And with that, the court will now issue the following orders. As to those 5 media files, the parties are to conclude their conferral as to which portions or which portions will or will not be used of those 5 media files by this next deadline. Also, if there's any additional witness endorsements or initial witness endorsements, they must be filed by this deadline. And if any party wishes to use an expert, that expert must be disclosed by that same deadline along with the CV for the expert. And Mr. Richards, you know what a CV is, correct?
No.
Okay, a CV is the equivalent of a resume for an expert. It actually stands for curriculum vitae, CB, curriculum vitae. And all it is basically a resume for the expert to say why they're expert, what type of training experience, classes they've attended, those that they've actually taught at themselves, recognitions within that industry. And also pursuant to Rule 16, I'm going to order that a summary of the expert be provided. In other words, tell the opposing party what the expert will be testifying to. So again, the parties are to confer as to these 5 media files of what will and will not be used by this deadline, conclude that conferral. Also, any additional or initial witness endorsements, if you're going to include anyone as an expert, you must designate at that point in time in writing that the person is going to be an expert. Tender over to the opposing party the CV for that expert and also a summary under Rule 16 of what that expert will be testifying to. That must be done by Friday, October 3rd. That if there are any objections to any redactions to that media or lack thereof, that objection must be in writing and it must be supported by a legal basis.
So if I just want to pay the fines now, you're obviously not going to side with me in this. So if I just want to pay the fines and walk away from it.
I'm not either siding with or for against anyone. I just follow the laws here in the state of Colorado.
My right to liberty is invalid. So if I just want to pay the fines and walk away from this, what?
No, you have rights and you have liberties, but also here in the state of Colorado, these are valid charges.
Not in the state of Colorado. I'm a man standing on land. I am not a dead entity inside of a state.
Okay. Would you like to enter into a plea agreement then with the people?
What are we looking at for fines?
Oh, I can do.
The court takes a short break so they can discuss the possibility of fees and fines, which is pretty ironic considering how quickly this entire argument started falling apart. Once the judge pointed out that the defendant's legal citations didn't actually support his position, the confidence seemed to disappear pretty quickly. However, they weren't able to reach an agreement, so the judge moved the matter to the following month.
I would, if you would like to see
So I
what
need
the
to-
discovery is and if you want to object to anything.
All right.
So there's some additional deadlines. And so we are back on the record on Robert Richards, case number 25T5884. He is present before the court and so is Ms. G for the people. And so if there are any objections to any redactions or lack thereof of those media files, in other words, people are going to use something that you don't think they should be able to use, or they're not going to use something that you believe they should be used. You must state that in writing and you must support it by a legal basis. In other words, you just can't say I object. I have to know why you're objecting under the law. And you must tender over to the court the media in question by that next Friday, which would be October 10th. Now, failure to, even though you may have submitted a written objection that's supported by a legal basis, if I do not also receive the media in question by that next Friday, October 10th, then the court will deem the objection to be abandoned. And the reason why is this, I don't have access to their discovery. And so I don't have the media files. I have to be able to have the media file to review it, to be able to rule on it. Now, within that same written objection, the opposing party, you may respond to that objection with your own legal basis. But if you fail to respond, the court could deem your refusal or failure to respond as a confession of that objection. And I could grant that objection as written. But irrespective of if there is a response or not, if a written objection is filed supported by a legal basis and the objecting party has tendered over to the court the media in question by that Friday, October 10th, I will issue a written ruling on the weekend of October 18th. And so with that, because there were no testimonial motions, all motions and notices have been addressed. JASP order is still in effect. The parties, if they so choose, you may plead out at any point in time. And so with that, anything further for the people before I order Mr. Richards back here for the trial?
Nothing further, Your Honor.
And Mr. Richards, anything further for you before I order you back? And so I do order you to be back here, and we will see you back here on October 22nd. That will be a Wednesday, and that'll be at 8:15 a.m. Again, Wednesday, October.
All right, everyone, that's where we're going to wrap things up today. He was scheduled to appear in court on Wednesday, but unfortunately, the court never reached his case. so we don't have an update just yet. But unless he decides to take a plea deal, there's a good chance we'll be following this right to travel case when it comes back to court. If you enjoyed the video, make sure to hit the like button, leave your thoughts in the comments, and subscribe with notifications turned on so you don't miss the next update.